I'm Rodger Citron, and I'm a professor and associate dean at Touro College, Jacob D. Fuchsberg Law Center. And today's podcast is brought to you by the Touro Law Review. And I am truly delighted to have two fellow professors from Touro, Laura Dooley and Deseriee Kennedy. We're going to talk about the film, A Civil Action. And before I ask Laura and Deseriee to just say a little bit about themselves, the inspiration for this came, I taught the law and literature course, a mini course really, over the winter session, and I asked the students to watch A Civil Action. And watching it, I was reminded that even though the book is now more than a quarter of a century old, right? It was published in 1995 and the film came out a few years later. I was still really impressed with how many issues relevant to what we teach, how we prepare our students to practice, came up in the film. And so that's why we're here today talking about it. Laura, do you want to say a little bit about, I'm going alphabetically here. Laura, do you want to say a little bit about who you are and what you teach and so on?
Absolutely. And thanks for organizing this. I'm Laura Dooley. I teach both civil procedure and torts. So a civil action, which is of course based on a real case, is at the intersection of my interests. So I've been teaching for more years than I care to count. But I've always had this interest in the civil justice system and access to the civil justice system, and particularly the jury's role in the civil justice system, which has some interesting ramifications here in the case that gave birth to a civil action. So I'm excited for this conversation, and I'll turn it over to Professor Kennedy.
Hi, thank you so much, Professor Citron and Dooley. I'm really excited to have this chance to talk to you about a civil action. And thank you to the Law Review for hosting the podcast. So I teach at Touro, and I've been teaching civil procedure for a very long time. And I also teach about families and the intersection of family law and criminal law. And I am really interested in how the courts intersect with people's efforts to obtain justice, primarily civil justice, and particularly as it relates to families, but really as it relates to anyone who feels marginalized by society. I'm excited to have this conversation today because I think the civil action brings up a lot of these themes. So thank you.
Yes, and we can start right there with the subject of justice, because this is not a John Grisham story. It does not have a triumph, or doesn't feel like a triumph at the end. And so I just want to ask, I'll go back to you, Deseriee, to just say a little bit about how you feel about the film from the things that you're interested in, from the perspective of the things that you've talked about, that you teach and study and write about.
Yeah, thank you. So I did civil litigation before I started teaching. And so the movie really resonated with me, sort of the idea of having power and resources in the civil litigation system and not having those resources, and what that means in terms of trying to achieve justice. And so I, to some extent, lived the reality in the film. But when I teach about the topic, I try to think about the system from an idealistic perspective, because I think the concept of having a court resolve disputes and having juries and being able to have a group of your peers help sort through the facts is really a great idea. But I think what happens in a civil action is you sort of peel back the sort of rose-colored glasses that I think a lot of us try to sort of teach our students about the promise of civil dispute resolution. And it really shows us the dirty underbelly, that resources can make a difference in litigation. And so I think it's useful because it does both, right? That Schlichtman represents the idea of someone who can feel passionate, even though they had in the past been primarily interested in winning for money, that they essentially got caught up in the story of these children and these families and became so passionate about the case that I think it blinded him and his ability to represent his clients well. The impact of that. So Laura, Professor Dooley, I'd love to hear your thoughts, because perfectly you teach both civil procedure and torts, and I know that you've got a very high regard for the jury system. So I'd love to hear your thoughts.
Properly constituted jury system. I'll put that little caveat in there. Yeah, absolutely. And I would piggyback on what you just said about the resource issue. It's a David and Goliath story on some level, but it's a weird permutation if you think about it, because as you mentioned, Schlichtman was a very successful plaintiff's lawyer, right? He's driving around in a Porsche. I have friends who do this. I have a pro-plaintiff bias, I would say, in general. I'll just admit that up front. And I have a friend who says, who works for a defense firm, don't let Professor Dooley fool you. It's a plaintiff's lawyer who drive around in Porsches. And Schlichtman's an example of that, right? He's made a career of doing very well in personal injury work, probably by picking and choosing the cases that are going to be, yield the big payout. But as you mentioned, he gets, actually he's initially drawn to the case, right? Because he sees W.R. Grace, right? And he sees these big corporations as potential defendants, and his eyes go cha-ching, and he's ready to jump on that wagon. But then he gets drawn into the story of the families and the pain that they've suffered having lost children to this cancer cluster allegedly caused by the dumping of the big corporations into the water table. And then he really does become the David versus the big Goliath corporate defendant that has the big fancy Boston firm, white shoe firm representing them, with the Robert Duvall character, which is such a character, right? Who's got the chair at Harvard, the whole thing, right? So yeah, to turn a little bit to the jury issue, as a proceduralist, one of the things that's so fascinating about the trajectory of this litigation is how much the jury was in the shadow of every tactical decision that was made on both sides, but the movie really highlights the decisions made by defense counsel. So there's this scene, it's a very moving scene, where they're taking the deposition of a parent of one of the children that's died. And the parent is asked, to describe the circumstances of the child's death. You remember that scene? I can't even hardly talk about it. I'm crying. Yeah.
It's extraordinary. Yeah, it's so powerful. Yeah.
It's so powerful. And the parents talking about, well, they said he'll be fine. They'll bring him in the next day. And we're on the interstate, and we pull over and he dies in his wife's arms. And the Robert Duvall defense lawyer turns to his associate and says, we can never let this guy get on the stand. The jury cannot hear this story. And that drives, I think, this whole motion to bifurcate, right? Because it's very much the defense counsel's strategy to try to break up the plaintiff's storytelling to the jury. And the way they accomplish that procedurally is by bifurcating the causation issue and making it all about hydrology and experts and science and numbers and none of this human interest. So
I'm going to just jump in there because I think that, yes, it's a defense strategy, but to what extent is it part of how the system currently works that you don't get to the jury, right? Fewer than 2% of cases actually try. And we're seeing an increasing number of cases that we all talk about in our classes that expand the role of judge as gatekeeper and keep the jury in the shadows, right? So when we talk about pleading, we all talk about Iqbal. When we talk about summary judgment, we all talk about Celotex and the trilogy of cases around summary judgment. When we talk about discovery, we talk about sort of how expensive it is, right? And so you can go on and on about the tools that judges increasingly use to manage litigation, which often can mean not getting to a jury. And that's not even counting the increasing respect over the decades for arbitration agreements where you don't even get into court. And so how much is this jury in the shadow problem a defense strategy, and how much is it how our system,
it's reality, right?
Changed, right, over the decades. So
right. That's fantastic. I couldn't agree more. And sorry, go ahead, Roger.
No, I mean, we're in it now, right? I mean, we've
We are
really
in
sort
it.
of gotten to the core of a couple of really important issues that run through, we teach civil procedure at Toro in 2 semesters, and we're really right in the heart of the first half of civil procedure 2. I'm hoping to have a discussion with my class about the film. Just, it's an optional exercise, but I thought it's really an instructive film on pleading, right? We see an early iteration of Rule 11. It's very well told. That episode is very well told in the book, that no one knows what Rule 11 is because the case is being litigated in the 1980s, I believe. And then, of course, there are these discovery and management issues, pretrial and trial management issues. And so you'll get the reference because I think we all use the Ezel case book. When we got to the Aquaslide case, I said for part 2 of the decision, there's a civil action thing going on here, which is that the trial court judge makes a decision. We're going to try one issue first and take a verdict on that because that will be efficient, right? It'll keep the case narrow and the resources expended will be less than they otherwise would. And even and in that decision, there's also this concern about what if the jury sees the plaintiff, the injured plaintiff, how prejudicial that will be, and that could be. So I feel like, the film is really useful in a number of ways in dramatizing what's at stake in the things that we cover in our classes. The other thing I wanted to note, I was actually, just surfing online a little bit before we met today, and Jerry Fasher, the attorney played by Robert Duvall, rest in peace. He passed away relatively recently. That is in the last couple of years. One of the things that you find is that he says that he really objected to the depiction of the judge, the trial court judge, Judge Skinner, in the film, that he really felt that wasn't fair. And I say that just to acknowledge that point of view. Again, this decision to bifurcate, I think that in the book, if I remember, it may even been called a trifurcation. Oh, we'll do, causation, and then we'll do liability, and then we'll do damages if necessary. That is, I think that it was even 3 stages that were contemplated. It's depicted in such a way that we can discuss,
well, it makes it seem like he was heavily influenced by the defense strategy. And there's even that scene where it looks like, what is this, an ex parte meeting? The plaintiff's lawyer says, like, it's an ex parte having coffee. There's some line like that, right? But it does seem like, and there's so many interesting facets of that, because if you have sort of a big shot, big firm person who's routinely litigating in federal court, he is more likely to have some experience and knowledge of the judges there. That's certainly sort of implied. Although Jan Schlickman was certainly a sophisticated litigator too, there's no doubt about that. But what I would say is, with all due respect to Judge Skinner, it's sort of baked into the system. This goes back to what Professor Kennedy was saying. It's sort of baked into the system. If you look at the Manual for Complex Litigation, for example, which the Federal Judicial Center, right, put its stamp of approval on, that sort of trial management technique that you're describing, Dean Citron, about bifurcating and trifurcating and so on, that stuff's encouraged, as are umbrella protective orders that suppress information. That's what we talked about today in my class, so that's on my mind. Right, so these things that you might say that cumulatively cripple the plaintiff's ability to tell their story to the fact finder of their choice, which is usually a jury. And that also includes the procedural devices that Professor Kennedy mentioned, the 12b-6 as informed by Iqbal, the Rule 56 as informed by Celotex. And I will add, because this is a topic of passion for me, the judgment as a matter of law, directly controlling the juries.
Which is currently big news, right?
Exactly, big news in Manhattan.
Right, the Sarah Palin case, and Judge Rakoff in that case announcing his decision on that motion before the jury came back. So I don't want to interrupt, so go ahead.
No, that's exactly right. These are all, I think they also connect to what we talk about in first semester civil procedure, which is federal subject matter jurisdiction and removal, and why many plaintiffs would prefer to be in state court, and it's the defendants that want to be in federal court. So removal is where the game is played. Is this where we can tell your anecdote, Dean Citron, about the partner who said, sit there until you find a reason to remove this case?
Well, you've opened the door, as they say at trial. Actually, I'll lead with something, on point. There is a teaching resource. I know that it's a professor, I think Professor Grossman, Louis Grossman. I don't know if he had co-authors or not. I think he teaches at American. Put together a documentary companion to the civil action book by Jonathan Haar. And I used it once or twice after it came out. And it's a very, very rich resource, because you actually get to see the pleadings from all the way through, but certainly there was so much pretrial activity there that you see, the original, the source documents for what's written about in the book and in the movie. On the removal point, the case was filed in state court, and the plaintiff, Schlickman, and his colleagues sought to avoid removal by naming a subsidiary as a defendant. But of course, that was unsuccessful, because in trying to destroy diversity by naming the subsidiary as a separate defendant, it doesn't work, and it didn't work. And so the case wound up in federal court before Judge Skinner. And Laura's referring to when I was in private practice for 2 years, a long time ago. In fact, this will tell you exactly when. The book came out while I was an associate in Philadelphia at a law firm, and we were sued in state court representing a defendant, and it was ordinary commercial litigation. But of course, our defendant was a partnership, and jokingly, the partner said, if you can come up with a way to remove this case to federal court, you'll make partner next year. I left a year later, still an associate. but but it was absolutely a mindset of uh, even in a business dispute where there would be parity and equals, it wasn't an individual versus a corporation. It wasn't David versus Goliath. The defendant, it was not in our best interest to be in state court. At least that's how we thought at the time.
And I think that's the conventional wisdom, right? For, all the reasons that we were cataloging before, that there are defendant-friendly procedural devices that are hoops or barriers to clear if one ultimately does want to get to a trial and specifically to a jury. But even the jury, just one more jury point, and then we can move on. Even if you did manage to clear all those hurdles and make it to the jury trial in federal court, the jury pool from which that jury will be drawn looks quite different than it might look in a state court drawn by county, which is another thing and if you think about most urban areas, if the city, the center city, right, is a county, the demographics of that jury pool might look quite different than a federal district that includes collar counties that are suburban. So it changes. Even if you clear all those hurdles, it changes the demographics potentially of the jury that you might ultimately have deciding the case.
There are still other aspects of civil procedure too, I think we need to discuss.
Fair enough.
And I mean that seriously, because when we talked a little bit about what we would discuss here on the podcast, boy, one of the most important issues raised by the case, and it's absolutely in the film, is, so what did the families want? That is, what we would ask the question in class as, well, what relief did they seek? What was in the prayer for relief under Rule 8.3? But I'd like to ask both of you to say a little bit about that, because it's a really interesting, part of the film and the book.
Do you want me to go first? Is that?
Yeah, please, Professor Kennedy.
I'm getting the professor's nod from Professor Dooley. I feel called upon. So I think they wanted two things. I think what Ann Anderson talked about, she was, I think, the lead plaintiff in the class action, was an apology. She wanted acknowledgement of what happened to her and her family, and most importantly, to her child. And I don't think the system is set up ostensibly for mea culpas, right? For wrongdoers to say, we did this wrong, we're really sorry. And then everyone can sort of walk off into the sunset as friends. And I think Fasher said during a scene when he and Schlichtman, played by John Travolta, were outside the courtroom, and they were discussing what was going on inside the courtroom. And Schlichtman mentioned something about truth, and Fasher's response was, you're not going to find anything that resembles truth in a courtroom, and that you don't look in a courtroom for truth, right? And so I think that's what the plaintiffs really wanted. They wanted the wrongdoers to say, yes, we did this thing. It resulted in the death of your child. And our system isn't set up for that. I think Fasher's absolutely right. It's not set up for truth. And I think I'll just end with this note that I think a lot of our students, when they come in, I remember this feeling of being shocked in law school when I found out that our system isn't set up to find the truth. And I think that's something that we are, as civil procedure teachers, left to reveal for our students during class, that's not what this is about. This is about resolving disputes and maybe getting to the merits. But the idea that there's some objective, neutral truth that the system's going to help us get to is unrealistic, at least in the system as it's currently set up. So, Laura, what do you think, Professor?
Wow, wow, yeah. So we can go all postmodern on this, right? Is there such a thing as objective truth that's at least accessible to human beings? That's beyond my pay grade. But I, sorry to do this, but this is where I harken back to the jury. If there is no way to get to an objective truth, then to me it matters not so much what the result is, but who gets to render it, and is the community participating in that? And I have to be very careful about this because juries have done some really bad things. We all know that. And I think a lot of times that's a function of the way juries were constituted in a way that is both unconstitutional and irregular, but we'll put that aside for now. There's got to be something vindicating for someone like Ann Anderson to have representatives of her community acknowledge her plight. And it didn't seem like it was about the money for them. I agree with you. It was really about the acknowledgement and to some extent, I think the vindication, and just to be heard, just to be listened to, right? Just to have a chance to tell your story. And that's why those seemingly technical procedural decisions like the bifurcation decision are so, they have such outsized importance that might not be immediately obvious, right? Because they really did hamper the ability of the plaintiffs to have that moment in open court with representatives of the community just to tell their story. And yeah, it's easy to get cynical, right? And to say, but we're so far from the reality we'd like to see. But I guess I don't want to give up on it, right? I mean, what worries me is that we're going, you mentioned earlier, not to touch arbitration agreements or other private dispute resolution that wouldn't even have the sort of public facing aspect of the civil justice system, which I would like to see preserved personally. I really worry about the privatization of dispute resolution because we lose that public moment of acknowledgement.
Yeah, and there are cultures and other systems that have built into their dispute resolution processes the opportunity for acknowledgement of harms, requiring people to listen to how the injured have been harmed and to try to come up with a resolution in the form of a mediation, right? So unlike arbitration, right? In a mediation or even in some forms of non-formal or some sort of informal dispute resolution, you can have some of that, right? That you can have opportunities for people to say what happened to them and have a voice in what the resolution should be. And maybe it's worth continuing to look at those other forms of dispute resolution.
Sort of like the victim offender meetings on the criminal side. Yeah.
Right. And
yeah.
circle sentencing and right. Absolutely. Right. Absolutely. But to be creative about how do we make sure that plaintiffs or those who are injured or feel victimized in some way are heard, and the court cases and changes in the rules don't seem to be moving in the direction they seem to be.
Sure don't.
The opposite direction.
They sure do not.
Yeah.
Struck by, in this last exchange and discussion, two things. One is each of us brings to this discussion not only our civil procedure experience, but what we also teach. So, the torts course and doctrine, informs how Professor Dooley thinks about what we've been talking about in family law. I think is, clearly part of, present in what you're talking about. So I also teach administrative law. And one of the things that we would talk about when I used the companion was the issue of, this was a complicated case in which there were really hard questions of science. There was the question of, did the contamination occur? There was the question of it, if it did occur, did it cause, or, in the legal sense, the cancer that the plaintiffs were suing about. And so, and this kind of, there was part of me sort of had introduced, well, really, aren't these types of questions best resolved by experts rather than lay people? And absolutely, some of the students would say, but what about the jury? What about the community? And so, of course, at the end of the film, we learned that subsequently the EPA did take action here. But it's really, both, dramatically and chronologically anticlimactic, because it all takes place, after the case is over. The second thing is, and this goes to what Professor Kennedy and what both of you were talking about, but I was especially thinking of it, because I think Professor Kennedy mentioned mediation. I would ask the students in a simple writing exercise, represent one side and write a memo to the lead attorney. Should we mediate this case? You could be an associate for Jan Schlickman, you could be an associate for Jerry Fasher, and just make a recommendation based upon that. And it always drew divided responses about, there were some people on the plaintiff side who said, because one of the assigned readings for alternative dispute resolution was Owen Fiss's against settlement, who said, this is really analogous. This is a Brown versus Board of Education moment for this community. And it has to be litigated in a public forum. Other people would say, the experience of the case shows that the clients didn't have a meaningful voice in the process. And the mediation, because we would also do other readings, mediation would give the families a more meaningful opportunity to participate and for them to tell their stories, perhaps not in public, but in the end, they don't tell their stories in court. So, there's the film really cuts across, I think, not only this question issue that we address in the course, but that any of us contemplating suit, right? A civil suit, as opposed to some other way to try and resolve a dispute or a grievance, whatever you want to call it, have to think about in nowadays. So, we've gone for.
Just quickly on that point.
No, I wasn't going to wrap up. I still have one more question.
Okay, I don't think this will surprise anyone for me to say, but I really worry about the loss of the performative, if you want to call it that, aspect of public litigation. That and you're absolutely right that it could be that in a private dispute resolution process, these particular plaintiffs might have felt more heard. But I think there's something lost when the rest of us don't know about it. And I really worry about what seems to be the trend. I think Professor Kennedy was really explaining this so nicely before. The trend seems to be toward privatization, both within the litigation process and outside the litigation process, just sort of, bypassing the litigation process altogether, to the extent that it's possible for that to be controlled in advance by likely litigants who are going to be the big corporations like W.R. Grace and others. And that worries me a lot, actually. And it's sort of the modern day version of Owen Fiss's concern back in the day, right?
And I think it's because the tension is our system about resolving the individual case and providing relief to the individual plaintiffs, or is it about creating law and
Right.
public policy that will then affect all of us. And I think that's really the tension there that we're talking about, that I think Dean Citron, when he started us off, articulated so well, is a civil action brings all of that to the fore. And it provides an opportunity to discuss these things in a way that is distant enough that people can engage in these discussions without making them personal. Because I think oftentimes people bring the personal into these discussions, and something gets lost. The other part of the movie that disturbed me a little bit, because it's a reflection of how things are done, is calculating loss of human life, right, through money, impacted by bias and prejudice, right? So Schlichtman does a speech about, the perfect plaintiff is a middle-aged white man in his, prime or 40s. I don't know if 40s is middle-aged, sorry. Right? And
40s is young.
Right?
Not necessarily.
And so you can also have a lot of great discussions about whether the judge is biased or whether this is just how the system works, whether tort damages are inherently biased, and what do we do about that in a world in which we are trying to surface these structural and systemic instances of bias and prejudice. And this film sort of unearths some of that and is great for discussion, because then again, it's not personal. It is, what do you feel about what Schlichtman said? What do you feel about the fact that tort damages are infected with these ideas about what life is worth that's impacted by bias? So.
And that's where I've routinely used, that's the opening scene, right? When it's a different client who's a paraplegic or quadriplegic. And right, he has that speech, and then the settlement offers start coming in from the other side when they see the fact finder sort of affected by that. And I think that brings up sort of an interesting subtext too, about that client in the wheelchair becomes almost a commodity that is being monetized, right, by both Schlichtman and the defense. And right, and so there's all the
theme all throughout, right?
Right.
That frustrates the named plaintiff in the Woburn case, right?
Right.
When she figures out we're just pawns,
right,
in the struggle between the plaintiff's lawyer and the defendants. I mean, you don't really care about what we want. Is I think that I mean, I think you hit the nail on the head. I think that's the theme throughout, and that's, I think for those of us who practiced, there were moments when you felt that way. Like, what is this really about? And does this have anything to do with justice? So yeah, beautifully said, Professor Dooley.
So our last, I've already noted that all of us teach something else besides civil procedure. And of course, we all contain multitudes. I'm going to allow you an opportunity. This is a really kind of almost like a law and literature question, if you'd like to engage your inner film critic. Who was the most interesting attorney in the film for you?
That's a great question.
Fine, interesting. What do you mean?
Yeah.
It's deliberately open-ended or vague, if you want to make that objection in the parlance of the discovery rules, so that you can really define it for yourself.
If by interesting you mean effective, like we probably have to go with Thacher, don't we? His tactics seem to pay off pretty routinely, both in terms of understanding that the Rule 11 tactic of the colleague who's defending the other defendant is probably going to backfire, to the bifurcation idea. And he seemed to also understand the power of the story, which is why he worked so hard, right, to keep the plaintiffs off the stand. And there's that scene when they're out in the hallway of the courtroom waiting for the jury to come back on the causation issue. And he says to Schlickman, what do you think is going to happen? I'll tell you what's going to happen. They saw the other guy's employee dumping directly. They don't have any direct eyewitness testimony about us dumping. It's going to come down to that. He seemed to sort of get the whole game of it. I hate to use that word, even though they do discuss that word in the movie as well. So if by interesting you mean effectiveness, I'd have to go faster. If by interesting you mean the character arc, then I think we've got to think about Schlickman, right? Who starts as this hotshot, arrogant, fancy suit, Porsche driving plaintiff's lawyer, who has really, I think at least we're supposed to get from the screenplay, has really thought of his clients as commodities in the past, and does get taken by the suffering of his clients, the parents, and in a way that may actually impede his work as a lawyer. So then we have all these lawyer identity issues that are important to think about for all of us and our students as lawyers in or becoming lawyers, to think about what distance should you have from a case or from a client to maintain your effectiveness. On the other hand, your passion is tied up with identifying with the people that you represent. And so I don't quite know what to do with that, but I think both of those things are there.
Yeah, I have to agree with everything Professor Dooley said, and I don't think I could have said it better. I think Fasher was clearly more effective because he was clearly more skilled in the procedural techniques and strategies that are effective in the system we've constructed. And passion doesn't win cases. And in that sense, I agree with Professor Dooley that Schlichtman was perhaps outmatched, outgunned. But also I think he was blinded by his passion for winning and winning big, because he let go of an opportunity to settle the case for more than he got in the end, because I think he was blinded by his own goals as opposed to his client's goals. Mm-hmm. But I think Schlichtman and his colleagues, right, his partners, I think are interesting because they are willing to represent people who can't afford attorneys. And I think it takes a special lawyer, a special person to go in saying, I am going to take the risks, even though clearly they engage in a calculus before they take on these clients. But they take on clients that nobody else is going to take. And that's an amazing thing, right? So whether it's legal aid, or you're working for a public interest group, or you're taking contingency fee cases, I think that's so important. And to take on a class action, right, which is a huge undertaking. I always tell my first years, we're going to learn about class actions, but you are never going to take a class action until you have some experience. It's embedded in the rules. Don't even think about it, right? Makes them fascinating. It's fascinating to think about what it takes to take that on, mm-hmm. right? To take on a case that is probably unwinnable, but think you can win it. And we need lawyers like that. We need lawyers who are going to take on cases that everyone else says you can't win, mm-hmm. right? Because maybe that community didn't get money. They didn't get what they wanted out of the case, but the EPA did come in and say, you've got to clean this up. And ultimately, I think that's the biggest win for all of us, right? And we're talking about this case, and we're talking about the fact that people who've been impacted by chemical dumping or pollution or bad actors in the corporate arena deserve to be heard in some capacity, even if only in a film and a podcast hosted by Dean Citron. That's an important thing. That discourse is important. And so in a way, those families won because those kids haven't been forgotten, right? we're still talking about them, and it still matters to people who they wouldn't know and are not going to know. And so I find Schlichtman and his partners interesting because they're willing to take on these cases that people can't pay a lawyer. Lawyers are expensive. So
Yeah.
Yeah,
that's what I think.
that is the perfect note on which to end.
Yes, it is.
So I'm gonna move to adjourn and thank both of you. Really, really interesting, really enjoyable discussion. Thank you, Professor Dooley. Thank you, Professor Kennedy. Thank you to the Toro Law Review for hosting us. And I hope to see you again on the podcast too soon, as well as around the school.